going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Eat your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? I hope you're having a great night so far. Happy Wednesday. Happy Hump Day. Sorry, I'm anxious. I'm not used to being on camera, so I'm a little nervous about it. So hi. You guys want to watch some court? I want to watch some court. Let's watch some court. Yeah, it's Wednesday. Happy Wednesday. I don't remember what I'm supposed to say. You guys want to watch some court? I want to watch some court. All right. I've got a couple good ones tonight. The first one I have is hold on. This is actually a hilarious comment. Jen, how does one pull over a speeding aircraft? And I thought it was hilarious because, the title does look like that. No, this is a speed trap zone where, the aircraft, the planes actually, record the cars and they radio down. That's what this is. That's what this trial is. I thought it was really interesting. It's not a terribly long one. It's only about 20 minutes. It's not, there's not a lot of drama. I just thought it was really interesting because I've never seen this before. And every time I go through one of those zones, I'm like, how does that even work? We're about to find out how it works. So yeah, we're gonna learn some stuff tonight. Mayor, 16 months. That is awesome. Thank you so much, Mayor. Good to see you. And Andy, the left-handed bandit, became a new member. Thank you so much, Andy. I do appreciate it. Welcome to the family. All right. You guys ready for some court? Let's do it. I've been working on my new intro, so I don't even remember what I'm supposed to say. Before I hit that play button, you know what to do. Hit the like and subscribe. Do your jump kick backflips. Let's go.
Trooper Evans.
Trooper, please come forward and be sworn.
You solemnly swear or do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, ma'am.
Oh, you wanted to know how I thought the plane tickets worked? All right. I will tell you exactly how I thought it worked. So there's lines, right? There's lines on the highways. So once you cross into a zone, the plane will start a stopwatch or however it times it, and then once you go through another line, depending on how long it took you to go from point A to point B, they could figure out your speed. But the planes are generally higher up; you can't see them in the distance, so you don't know that they're actually clocking you. That's how I thought that. That's how that's how I thought it worked. Yeah. Wait, we got Big In Raid. Thank you so much, Big In. I appreciate it, my friends. My friend, acting like Big In is more than one person. Big In, you are awesome. Thank you so much. I do appreciate the raid. Welcome to all the Big In Raiders. We just started. We are about to play a case where someone is fighting. They're contesting a speeding ticket that they got from an airplane. That's what we're about to watch. I just found it's really, really interesting because we're about to find out exactly how this works. So yeah, if anyone's ever gone through a speed zone where it said, what does it say? Speed enforced by aircraft, I think is what the signs say. We're gonna hear exactly how it works. Okay, let's go. Big In, you are awesome. Thank you.
Yes, sir.
Thank you.
For the record, give your name and spell your last name
It's Trooper Jeffrey Evans, and it's EVANS.
and the address of your post.
It is 2829 West Dublin Granville Road in Columbus.
Thank you.
You may inquire.
Thank you. How long have you been with the Highway Patrol?
I've been with the Highway Patrol for just over 13 years now.
And what are your current duties with the patrol?
I'm currently in the aviation section as a trooper pilot, if you will. So I've been in aviation now for roughly 8 years, come August, or just as August passed. So just over 8 years I've been in that section.
Okay, and how long have you been flying total?
Since 2018.
And the last 8 years you've been flying for the patrol?
Yes, sir.
When you're operating a patrol aircraft, can you check the speed of a vehicle on the ground?
Yes.
Can you describe how that's done?
Yes, so it's done with 2 stopwatches or a stopwatch. If you're checking one vehicle speed, and there's markings on the roadway, typically they're a mile long for a zone, and then we check out 4 different quarters.
Amazing. Amazing. I'm not gonna lie though, it tasted exactly like I thought it was gonna taste. It was good. It was good. That's all I got. I mean, fries, gravy, and cheese curds. I mean, I've had all those 3 combined before, just never in Canada. But yeah, it tasted exactly like I thought it was going to. It's good. It's fantastic. That's all I got. That's all I got. It didn't blow my mind. Wasn't any different than the one I've had, in the States. So it tastes the exact same to me. But you Canada might kick me out for that, but we're gonna keep going.
That would be a quarter mile. So 1,320 feet is that mile. The little white marks are 2x4 markings on the roadway. When the first part of the vehicle or the hood of the vehicle crosses that line, we start our stopwatch, and then as it goes through that second marker, we'll lap the watch, and then it computes everything in that watch, gets the mathematics, and tells us a speed.
And you mentioned utilizing watch.
Jedi, first off, I'm sorry that am I loud? My volume for the video is the same as it usually is. Maybe the cord is a little bit quiet tonight. I don't know. I will try to speak a little bit more soft. But Mayor started a new channel. He started a new channel. Everyone go check him out. There's his link. He dropped it. Go drop him a sub. And yeah, Mayor, best of luck to you on your channel.
Do you have a procedure that you check the watches for their accuracy and proper operation?
Yes, there's 2 different functions or 2 different tests that we do, if you will. The first one is going to be a monthly check, and that's going to be a check where we monitor the frequency from Boulder, Colorado, which is from the atomic clock. We run those watches for a duration of 2 minutes, and it's done on or about the 15th of each month. Once that is checked to be within the tolerances of 1/10 of a second off of the 2-minute mark. If it's found to be outside of those restraints, we throw the watches away. We don't replace the watches, or replace the batteries of the watches. And then we also have another one, which is a comparison check, which we're checking the watches for the mathematical part of it. We run the watches for a duration of 16 seconds. And then when we stop that watch, we check our comparison chart, make sure the mathematics works out to be exact. If it is not exact to that comparison chart, then we throw those watches away.
Okay. And how often, you mentioned a monthly check. Do you know when the monthly check would have been done prior to July the 5th of this year?
Yes. So for this specific one, it was done on June 2nd of 25, and then just after on July 11th of 25.
And the watches were working correctly for the monthly checks?
Yes, sir.
And how about when you're checking one watch against the other? How often is that done?
Andy, happy birthday. I appreciate the super chat. I also appreciate that you are spending part of your day hanging out with us. That is awesome. Thank you so much, Andy. Hopefully you had an amazing day. And thank you again for the super chat.
That's done before and after each zone. And so at the beginning of each time we check in to work with the units on the ground, we'll start those watches, check the calibration of them, and then into that zone as well.
Okay, and that would have been calling your attention to July 5th. Do you have a time about when you would have done that on that date?
Yes, sir. It's going to be at 10:30 in the morning, and then at 1400 after the zone.
And again, were the watches operating correctly?
Yes, sir.
And again, calling your attention to July 5th, 2025, at about 12:55 p.m. Were you operating a patrol aircraft?
Yes.
Did it have any special markings?
Yes, it's got the flying wheel of the Highway Patrol emblem on the left side of the aircraft, and it has State Patrol across the wings of the aircraft as well.
And were you wearing the distinctive uniform of the day, similar to what you're wearing now?
Yes, sir.
And geographically, where were you at that time?
We were in over top of Interstate 70, approximately milepost 132 in Licking County, Ohio.
Do you know if it's Licking Township as well?
Licking Township, yes, sir.
And on that time and date, did you have occasion to check the speed of a vehicle traveling westbound on Interstate 70?
Yes.
And describe how you did that or what you observed.
At 12:55 approximately is when I called this vehicle off and marked that the vehicle was in the right lane as it was passing traffic, and then slid over to the center lane as it exited the zone. There was no similar vehicles with that vehicle, and it had went over to the left lane after the zone where our ground units were sitting. I let them know that I had a vehicle. They intercepted in the left lane and then activated their lights, I'm assuming, and then conducted their traffic stop, went to the right shoulder, and then stopped the vehicle. I confirmed with them that they had the correct vehicle, the speed, and the time.
Did you ever lose sight of that vehicle?
No, sir.
And were you able to track the speed of that vehicle on all four quarters?
Not on all four. In the first quarter, I was not able to grab a speed on the vehicle. But however, I got the second, third, and the fourth quarter, and the speed that I had on the second quarter was at 95 miles an hour. And then the third quarter was at 92 miles an hour, and then slowed significantly at the exit of the zone, which is the fourth quarter, at 78 miles an hour.
Now, did you ever lose sight of this vehicle?
No.
And how do you relay to the ground troopers that they have the right vehicle?
Over the radio, over the police radios from my aircraft down to them, we'll be on a specific frequency, and I'll just let them know that, we've got this vehicle coming through the zone, give them an idea what the speed is. Once it exits the zone, I tell them what speed we're going to take enforcement on, and then let them know a countdown, if you will, of the vehicle as it's getting ready to pass by them. And then as they're pulling out of the crossover or where they set up, they'll get in behind that vehicle. I let them know they're behind the correct vehicle, and then they'll take it to whichever shoulder that the driver of that vehicle.
She has way better internet than mine. Yeah. I think I'm coming through clear. Hopefully I am. If I'm not, I'm sure you guys will let me know. But yeah, it's been a great time here.
Chooses, I guess.
And once that vehicle was stopped, did you radio down the 95 mile an hour as well as the time?
Yes. Once it went to the right shoulder, I let them know that we were going to go for 12:55 was the time, and then at 95 was the speed we were going to take enforcement on.
And I think you had indicated earlier the vehicle that you were observing passed other vehicles?
Yes. It was in the right lane. It was passing vehicles in the right lane as it had moved to the center lane.
What was the altitude of your aircraft when you were doing this?
I was at 3,500 feet when I was flying over the zone.
What were the weather conditions?
Weather conditions, light winds. It was clear, so not a cloud out there. 10 miles of visibility. So crystal clear blue sky.
Okay. And were you convinced beyond any sort of doubt that they, in fact, the ground troopers had stopped the correct vehicle?
Yes, sir.
Okay. I have nothing further.
All right, so Ms. Powell, do you have any questions for the pilot?
I don't know, I do not.
All right, Trooper, you may step down.
Thank you, sir.
Your next witness?
We would call Trooper Duvall.
All right, please come forward and be sworn.
Do you solemnly swear or do you affirm that the testimony you're about to give is the truthful truth, nothing but the truth, and nothing but perjury?
Yes.
Please have a seat, sir. For the record, give your name and spell your last name.
Trooper Tristan Duvall, D-U-V-A-L-L,
And the address of your post.
3855 Outville Road in Granville, Ohio, 43023.
You may inquire.
You work for the Highway Patrol.
Yes.
You were so employed back on July 5th, 2025.
Yes.
Were you riding with any other trooper?
I was riding with my coach at the time, Trooper Jared Miners.
And since you were working, did your duties on July 5th, 2025 include the enforcement of the traffic laws of the state of Ohio?
Yes.
Wearing the uniform of the day, similar to what you're wearing now?
Yes.
And were you
Thank you so much, Therina. I appreciate it. I know you're not talking about me. I was just having some fun. Let's go.
operating a plainly marked patrol cruiser with all required markings, lights, including the working overhead light bar?
Yes.
And at about 12:55 in the afternoon, could you tell us what you were doing?
So I was patrolling on Interstate 70 westbound when I was notified that the aircraft was coming out. We started working with the airspeed zone, and we were notified of a car that was going 95 in the 70. So we pulled it. I identified the car, I attempted to flag it down, pulled it over to the berm. Once I got over to the berm, conducted a traffic stop.
You say you attempted to flag it down. What do you mean?
So I was outside of the vehicle. I pointed and tried pointing over to the right side of the berm, try to get him over without having to go and pursue. And then didn't see the symbol, so we ended up going up, activated overhead lights, and then initiated the traffic stop, pulled over.
And car complied and pulled to the right.
Yes.
And did the pilot tell you anything when you had the vehicle stopped?
The pilot indicated that I had the correct vehicle on the right berm and said it was 95 at 12:55.
On the highway, you're familiar with this airspeed zone?
Yes.
Is that in Licking Township, Licking County, state of Ohio?
Yes.
And are there markings off to the side of the road for quarter miles?
Yes, there is.
Have you personally measured those?
Yes.
And are they at least 1,320 feet apart?
Yes, sir.
Andy, thank you so much. I appreciate very generous super chat. Thank you so much. I had a lobster roll on Monday night after the soccer game, and it was fantastic. It was fantastic. I had a little conversation with the bartender and asked him to do it without mayonnaise. Like, like lobster rolls are generally like tossed in some sort of mayo. I'm like, can we not do that? Can you use butter instead? And they did it, and it was fantastic. So, anyways, Andy, thank you so much. Very generous of you.
And once this vehicle stopped, did you make contact with the driver?
Yes, I did.
And is she in the courtroom today?
Yes, she is.
Point her out, if you would, for the court.
Is the white female wearing the approximately purple shirt, sitting right over there.
And what's the speed limit for the entire air zone?
70 miles an hour.
Nothing further, Your Honor.
All right. Ms. Powell, you have the right to question this trooper as well. Do you have any questions for him? No. All right, trooper, you may step down. Thank you. Any additional witnesses on behalf of the state?
No, Your Honor.
Okay. So, Ms. Powell, as you sit there, I have to presume that you're not guilty of this offense. The state has a burden of proof beyond a reasonable doubt. You have absolutely no obligation to call witnesses, present any evidence, or testify on your own behalf. It doesn't lower your presumption of, or diminish your presumption of innocence, and it certainly doesn't lower the state's proof. But you do have a right to present a defense by calling other witnesses, introducing exhibits into the record, or testifying on your own behalf. So other than yourself, do you have anybody you'd like to call? And would you like to testify on your own behalf?
Yeah.
Okay, please stand.
This is where I give just a statement.
You're just going to give me your side of the story after you're sworn.
Do you solemnly swear or do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes.
Please have a seat. For the record, give your name and spell your last name.
Haley Powell, Powell.
And your address.
3415.
Why? Stop asking for people's addresses.
You said basically it's just you giving me your side of the story, and you can start whenever you're ready.
So since July 5th, I've had to borrow my fiance's car, and I'm used to driving a Ford Explorer.
No, it's not a Canadian thing. It's a kind of like a New England thing. Lobster roll, like, at least in my opinion, it is. It's not very common in Ohio, but when I go further east, it starts popping up everywhere. Heather just wanted to take me to this one specific lobster roll spot. Over it's close to Peggy's Cove. We didn't actually get to Peggy's Cove though, because we're gonna go on Saturday, but the weather was not great on Saturday, so we didn't do that, and we instead had a lobster roll for dinner yesterday. So I still haven't been to Peggy's Cove yet. That hasn't happened. The weather was bad, but yeah, that's all I got.
Which is a lot heavier and harder to accelerate. So during this time that I had past the vehicles, I did know that I realized I was speeding. I was going fast, and when I looked down, it was 85, and I quickly decelerated my vehicle and just continued my drive to work. And I did see the state troopers outside, and I did not realize they had pointed at me. I didn't think I was in trouble for anything. Because I quickly corrected myself once I seen that I was speeding.
Yeah, absolutely. People just don't know how to argue. They don't know how to fight speeding tickets. I said this in the intro. This one's not crazy exciting. I just thought it was really interesting to hear the process with how speeding tickets are written by aircraft. So that's why we're watching this. It's almost over though. She did admit guilt. She doesn't fight it. I don't understand why she's contesting it, but to each their own.
But when they did pull me over and they told me I was going 95, I let them know, like, I was passing vehicles and there was an aggressive situation with 2 other cars, so that's the only reason I was passing them. And I told them too, I didn't know what speed I was going, but I did not think I was going 90. So after the fact, I went on my Life 360 app to see if it tracked my speed, and it said 88 miles per hour for that day was my top speed, which I brought that with me. I don't know if you need to see it or not. However, I also feel like too that I don't know, like, I don't want to say that his equipment was wrong.
All right. Is there anything else you'd like to add?
No.
Okay. Mr. King, do you have any questions for the defendant?
You indicated that when you looked down, you were going to 85. Do you know where that airspeed zone was?
What the speed limit is for there?
No, speed limit's 70 miles an hour
Yeah.
through the whole thing. Did you even know you were in an airspeed zone?
No.
Nothing to do with it.
Okay. You have a right to respond to what he asked you, but you don't have to. It's called redirect examination. Was there anything you wanted to add to your testimony based upon his questions?
No, I didn't even know what a airspeed zone was until now.
Okay. All right. Well, you can go ahead and retake your seat there at your table. You've already indicated you don't have any additional witnesses, so do you rest? Meaning you're finished presenting your side of things? Okay. Just go ahead and have a seat. Mr. King, did the state wish to present testimony or evidence in rebuttal?
No, thank you.
All righty. Did the state wish to make any type of argument?
At this point, we'd rest on the testimony.
Okay. So you have the right to make what's called a closing argument. It's not required, and it's not evidence, and you can't bring up anything that wasn't testified to either by you or the 2 troopers. But it is your chance to argue why you think the state has not met its burden of proof here. Is there anything that you'd like to say before I make a decision and render a verdict?
I just thought maybe there was something wrong, but it could have been my phone.
Okay, and feel free to help yourself to a tissue if you need one. All right. So basically, what the court heard was testimony from both sides, one scientific and mathematical, and the other one kind of based more on feelings and memories. So the court finds Trooper Evans' testimony credible that A, he knows how to fly a plane, B, he knows how to work the stopwatches, and C, that they'd been checked both monthly and on the date in question and been found to be functioning properly. Court further finds his testimony credible that he noticed a vehicle that he visually estimated exceeding the speed limit as it entered the airspeed zone and was able to determine speed in the last 3 quarters, the highest of which was 95. Further testimony showed that the ground unit pulled in behind the vehicle that the pilot had just clocked, confirmed that with the pilot, as well as the speed, and ultimately upon making the traffic stop, identified the defendant as being the driver of the vehicle. On the other hand, we have the defendant's testimony in which she says that, one concrete thing you can say is, I know I was going at least 85 because I looked down at that point. There's a lot of vagueness about exactly when in this whole process, and, I think peek behind the curtains. I think Mr. King's question was designed to establish that you don't know whether or not you were still in this airspeed zone when you looked down and saw that it was 85 miles an hour. And for what it's worth, if you ever see those little white hash marks on the side of the road, have you ever seen those on like expressways? Okay,
No.
well, if you ever do see it, you're in an airspeed zone. So if it's cloudy, don't worry about it. If it's clear, then you need to be careful. All right, so I do find that the state has met its burden, and I'm going to go ahead and enter guilty finding at this point. Anything you want to say about the fine? No? Okay, Mr. King, any input on sentencing?
We defer to the court, Your Honor.
All right, where do you work, Ms. Powell?
I work in catering.
Okay, but I mean, like, is your office, for lack of a better term, kitchen in Columbus?
Yeah.
Okay, and how long have you been doing that?
Since November of last year.
Okay, but have you worked food service in the past?
No.
No? Okay, so what do you actually do for the catering company? Like business side of it or food side of it?
Like the food, so I'm a server.
Okay.
And an apprentice to the coordinators too, so I help them out.
Okay. August still. Okay, so it looks like based upon the unofficial printout, you did not have any moving violations within the 12 months prior to being ticketed in this case, which means that 25 miles per hour over the speed limit, that's going to be a fine of $49. I'm going to order that you pay the court costs. It'll be a little bit more than what it would have been had you simply mailed in your check. There are some court costs associated with actually having a trial. It's not punishment, but the cost of doing business, for lack of a better term. You'll get time to pay, and you'll get all the details when you get down to the clerk's office. Now, you do have a right to appeal my verdict, as well as the sentence that I've imposed. You have a right to file a notice of appeal within 30 days of today's date. You have the right to pay for a transcript of our trial, and you have the right to hire an attorney to represent you if you wish, or you can obviously represent yourself on the appeal. Just understand that the appellate process is a lot more complicated than the trial court level, so if you decide you do want to take it up, I would strongly recommend that you, at the very least, consult with an attorney, if not outright hire one. And if you don't want to challenge it, you know, the decisions that I've made here today or the
Just to make, because I know people, every time we watch this court, people make those comments. They don't include the court costs. They only include the fines when explaining the sentence. So it's $49 for the speeding ticket, but I think standard court fines is about $150. So this ticket's going to cost her a little over $200 at the end of the day. So the $49 is just the fee alone for the ticket, but then all the other fines do tack on top of that. It's not just $49.
this fine that I've imposed. You don't have to do anything other than pay off your fine and your costs. So do you have any questions? Anything further, Mr. King?
No, Your Honor.
Anything else? Well, there's nobody else to ask. All right, we'll take a brief recess and then we'll come back in and handle our pre-trial.
All right.
All right, Ms. Powell, you may go to bed.
All right. I don't remember what's next. What is next? We're caught up on super chats. Let's go. Oh, I kind of feel bad playing this one. I'm not gonna lie. This one, this happened yesterday. I know OSG played it. A lot of people played it yesterday. I didn't release the video and I didn't go live last night. It was Heather's 5-year anniversary for starting her business. So I took the day off and spent it with her. Hey, look who's here. Hey, Heather. Weird. So but this one is you're gonna go through a wide range of emotions if you haven't seen this one yet. That's what I'll say. Let's go.
All right. Ypsilanti Township versus Rashivia Gunn, case number 25T00096.
Paul Barnett on behalf of the township.
Allison Muller here on behalf of Rashavia Gunn. Ms. Gunn, can you please unmute and turn your video on and then state your name?
Rashavia Gunn.
So Ms. Gunn is here today on a pretrial as well as a testing issue. She was positive for cocaine. She was before the magistrate. And apparently the 10% bond has still not been posted, so technically she's still in warrant status. She did earlier when she said her name. So what is the status of her testing at this point?
So, Your Honor, this was a little bit of a unique situation because I think my understanding of the testing order is that the substance testing was removed by, I think we had asked at her last hearing that she not be tested for substances, and then she was ordered to ETG test, and that's actually where the cocaine positive came from. They were only supposed to do an ETG, but the testing facility in Adrian collected for substances as well. So right now, I believe she's only supposed to be on her SoberLink, which she is still, and she's still blowing into the SoberLink.
Wait, you want me to ignore that she tested positive for cocaine when there's a court order, regardless of whether she's supposed to test or not, that she's not supposed to use any drugs?
No, Your Honor, I was just updating about the status of, I don't think she's currently testing further for substances other than that one result that we have. So she has currently, and since the arraignment and since that violation, just been blowing into her SoberLink.
Ms. Johnson or Mr. Pappingham present to let me know what her ETG test is.
Given that she's testing it, good morning, Your Honor. Given that she's testing it in Adrian, I would need to reach out to the community corrections agent to see if they've gotten those reports and if we have an updated progress report from them.
All right, I'm going to pass this to do that. And when we come back, ma'am, you tested positive for cocaine and arraignment violation at this time. It is still a violation of your bond conditions. And right now there's a bench warrant outstanding, which probably is going to remain outstanding. So right to have a hearing on the violation, at which time if it is found that you violate the terms of your bond, your entire bond could be revoked. Right now it's set at 10%. Ms. Moeller, have you talked to your client about all of that?
Yes, Your Honor, we spoke about it.
All right, we'll pass it and see where we're gonna go. Thank you.
All right, we're gonna fast forward a little bit. Andy, thank you so much for the super chat. Slap the like button. Wait, Fee? Slap the like button. Fee? LOL. Yeah, hit the like button. Yep, everyone hit the like button. I would appreciate it. Andy, thank you so much for the super chat. I do appreciate it. Again, if you have seen this one, don't spoil it. This is again. I'm just gonna hit the play. We'll watch it together. I'm not gonna say
Matter
anything
of
else.
Ypsilanti
I don't need
Township
to.
versus Rashavia Gone, case number 25T00096.
Paul Barnett on behalf of the township.
Allison Muller here on behalf of Miss Gunn. Miss Gunn, can you please unmute and turn your video on and state your name?
Rashavia Gunn.
Thank you. All right, I'm in receipt of an updated progress report regarding Ms. Gunn. Have you had a chance to review that?
Yes, Your Honor, I have.
Mr. Barnett?
Yes,
Okay.
I've also received that and reviewed it, Your Honor.
All right, thank you. All right. What does your client want to do with respect to the bond violation of testing positive for cocaine on August 19th, 2025?
Your Honor, Miss Gunn will admit to that violation, and then I would just allocute on her behalf when appropriate.
Thank you. Ms. Gunn, please raise your right hand to be sworn. Do you swear or affirm that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Thank you. You may lower your hand. Ma'am, as I indicated, you have a right to have a hearing as to the amount, I'm sorry. You have a right to have a hearing on the violation of cocaine in this particular case. It's my understanding you want to waive that right and you're going to admit to the violation, is that correct? Did we just lose her?
No, she just turned the camera off and lost audio. She's back with audio.
Ms. Gunn, is it true you're going to waive your right to have a hearing in this matter and you're going to admit to the violation by testing positive for cocaine?
I'm sorry, Judge. My camera went off and I did not hear anything you said.
Can you hear me now?
Yes.
Is it true you're going to waive your right to have a hearing on the violation and you're going to admit that you tested positive for cocaine on August 19th, ma'am?
Yes, ma'am.
All right. And I find that there's a knowing and willing admission to the violation. Are you satisfied? Mr. Burton?
Yes, Your Honor. Yes, Your Honor. Thank you.
Defense is likewise satisfied.
Thank you.
Yeah, go ahead, Mo. You can do it. We still have about another minute or two before it actually goes down. It happens after the hearing's over. But yeah, I will pause it and let you say it. I will.
What would you like to say on behalf of your client, Ms. Mueller?
Your Honor, Miss Gunn does admit she did use cocaine in this instance. I do think she seems pretty self-aware in that she realizes maybe how some mental health issues contributed to this, as well as her being pretty susceptible to the people she's spending time with, and maybe a little bit of peer pressure and just going along with things. So she does understand this is really a matter of putting herself with the wrong people and avoiding that in the future. She's not a regular drug user. I believe this was the first time she used cocaine. She will test negative going forward for any substances. And we've also talked about the marijuana and that must be discontinued until she would be given any kind of permission, if that were even ever to happen from the court. She understands that. I do think it's really positive for Ms. Gunn that I think there was an initial straw issue, but once that was corrected, she's done really well on her SoberLink. She has been abstaining from alcohol, and I know she'll continue to do well on the SoberLink. And I do believe that she will test negative for substances going forward. I think she learned a lot from this testing positive and kind of the repercussions that can happen by getting the bench warrant and having that over her. She's been really fearful and really hopeful that the court will give her a second chance and let her prove to the court that she's taking it really seriously being on bond. Mr. Barnett and I have a possible resolution. We are going to be asking to adjourn that today, of course, given the testing issues that have come up, to see if Ms. Gunn can test negative until the next pretrial. If the court would remove the bench warrant, allow her to continue testing for substances, remain on the SoberLink. She's already had her assessment, so that's great. I've provided that to Mr. Barnett. I know the outpatient or the assessment's recommending outpatient, so her and I have discussed that, and she's definitely willing to engage with that or anything more that might be ordered. So our request at this time is if the court would remove the bench warrant and give us an adjourned pretrial date.
Thank you. Mr. Barnett?
Thank you. Clearly, she's struggling pretty significantly. I wasn't aware until today how significantly. It's fortuitous that test was done, because it gave us.
That is exactly my thought. I know this comment is really late, but this is the last video. But yeah, how many tickets do they need to cite or issue to make up the money for the pilot and the plane? That it doesn't. I don't think it works. I don't know. But thank you, Ha.
An insight. Absolutely, testing for controlled substances needs to be added. She needs to continue to test for alcohol as well and be compliant. It just sounded like there was some gamesmanship with the straw and just testing in general. So that needs to be done properly for us to get a better sense of where she is. In terms of any sanction, I would leave that to Your Honor.
Thank you. Well, it certainly appears that she has figured out that this is serious. She has started to test appropriately. She, since August the 19th, has tested each and every time, and she has been negative, and her results with the straw have greatly improved. Apparently, she said she found those. So I am concerned about the cocaine positive. Do I believe that it was a one-time? No, but she can prove to me that that's correct. Because I'm gonna have to test. Ma'am, please move around. I'm gonna have her test 2 times per month, and then we'll see really where she is. Okay. So it'll be 2 times per month with the drug testing, and she'll continue on the SoberLink as she has been. And I'm bring this out to October 7th. Is that enough time, Mr. Barnett, for you to get some idea where she is?
I think so.
Okay. October 7th.
All right. So case is over, right? Judge Washington recalled the bench warrant for the dirty testing. She just has to test twice a month. So yeah, everything is good, right? Nope. Mo, I told you I'd pause it and let you say it. I'm waiting. Mo's about to do it. It's about to go down. Not in a good way. This is kind of sad how she blows up. There's some underlying issues. Yeah, there it is. There's some underlying issues here, and it's like I said, I kind of feel bad playing this, but it's an interesting case. Like everything's done. Everything's done. We can just hang up and walk away, but that's not what happens.
2025 at 9:00 a.m. for pretrial. Bond is otherwise continued. Bench warrant is recalled. All right, ma'am. This is your last opportunity. Please make sure you follow through with the court's orders, okay?
I did not do cocaine. I never did that in my life. I was hanging around the wrong people at the time. I never did that in my life. I promise to God on my life, I never did that in my life.
Thank you, Ms. Gunn. You'll show that through your future results, okay?
All right, Ms. Dunn, we'll see you on October 7th, okay?
Can I leave now?
Yeah. Okay.
Thanks, everyone.
What are you saying?
I'm gonna go fucking kill myself because this is ridiculous. I never did cocaine in my life, and this is hurting me, and I'm already in a freaking shelter for domestics, and this is crazy. I never did that in my life. I have a son I'm trying to take care of, and this is just overbearing for me. Like I'm mentally challenged. Like I never did any of this in my life. The only reason why I'm smoking is because I was in a car accident and my leg hurts and I have arthritis. That is the only reason why I use marijuana. If that was the case, I wouldn't even be doing this right now.
All right, I guess Ms. Gunn is very unhappy with the results, which was a bench warrant being removed and her being given a second opportunity for her to go on a tirade. So maybe what we need to do is just reissue that bench warrant and get her in custody. So, and the other thing, Ms. Moeller, that you probably need to do is to call CMH or somebody because she just made a threat against her life.
And they're telling me I don't care. I'm sick of this. I never did that drug in my life. I never did it in my life. I was just hanging around the wrong people, and they're doing this to me. And I never wanted to deal with this. Like I never did this in my life, and this is frustrating to me. I never did this in my life. Never.
The bench warrant is not called. She needs to be picked up, apparently. I'm canceling the next court date.
You're doing the next court date?
They said October the 7th, but it's like, I swear, I'm doing the alcohol. I'm done doing alcohol. I'm done. Like, it's just,
Just listen to what they have to say.
I already listened to what they had to say.
Okay. Let me get you some water.
You know who's there with Miss Gunn?
And I'm not sure. I think she said she's at a shelter, so it might be a worker there at the shelter. I'm not. She said something about domestic. I don't know if this is a special kind of shelter for.
Well, I'm gonna reinstate the bench warrant and I'm canceling her court date. And you should contact someone with CMH.
I will, Your Honor.
Thank you.
Yeah. Yeah, that happened. That happened. Like I said, it was that's sad. There's some underlying issues going on there. I'm not about to guess what they are, so I'm definitely not about to do that. And I think I'm back. The internet dropped for 1 second. It looks like it's back up. Real quick, Lizette, thank you so much for the 19 months. I appreciate it. That is awesome. 19 months. Thank you. And Cheshire Cat for 15 months. Thank you so much, Cheshire Cat. I appreciate it. Thank you. All right, let's move on. Let's just get that case out of here.
Close the case of the People versus.
I don't remember I don't remember putting Simpson in.
Jennifer Carlara.
Oh God.
That's called the people.
Good morning, Your Honor. Marissa Boyles, P86438, on behalf of Ms. Gallara.
Morning.
Good morning. You're
Jennifer Gallara.
Thank you. All right, what are we doing on this case?
Your Honor, we would be sorry, go ahead.
Go ahead.
We'd be requesting an adjournment on this. We have received discovery. She does have a substance abuse evaluation scheduled, I believe, within the next couple weeks here, as well as a hardship case scheduled for October 1st. We would be requesting an adjournment.
Bond violation.
I have. And counsel, are you aware of the bond violation?
I am aware of it.
All right. Would you like to address that?
I do believe she has a court date scheduled on it within the next couple weeks as well. It is for driving without a license. There are some underlying issues regarding the status of her license. So if we could adjourn the bond violation to the next pretrial, I think that would be best.
Anything from the people on the bond violation?
It's concerning, of course, to the people that she was driving. But most concerning to me was the fireball in the back.
Yes.
So those are sort of the things that I would put forward to the court. I don't know if there would be a resolution necessarily like that. Where do we go from here, right? Like she's driving, she didn't have her 625G and she had fireball. That's very concerning when someone's on bond for an OWI. I think, let me double check these notes. She had gotten a sober link because she was found to be in possession of alcohol, and I understand that she was saying she didn't know it was in the car. I am going to request that the court consider putting her on a scram tether. This is sort of a red flag to me.
Well, there are a couple of things. I guess I'm a bit concerned about why did she have her 625G permit or no?
She did initially, and then she only later received notice of the implied consent refusal, which she also did refuse. She just had trouble blowing. So she did have the permit and then only received that later. So, I mean, there were kind of some issues as to why there was the implied consent violation, and we are fighting that in circuit court right now.
Yeah, but she did know at the time that she didn't have a 625G permit. Did she not? Counsel?
That I don't know.
part of the problem that I have here, counsel, is that she's driving. She's not supposed to be driving. And then there is Fireball whiskey in the back of her vehicle. And she's not to be in possession or consumption of any alcohol.
I do understand that, Your Honor, and to my knowledge, she has been sober since the offense, doing everything she can. So I don't believe she had any knowledge of that Fireball being present. As we have gone over her bond conditions with her, and she is very aware.
25. Okay, well, counsel, if you want to get down here so we can address this later, but at this time, I'm going to take her into custody. Your bond on the warrant that I issued is set at $25,000 cash surety. So she can post, or you can come down and I can have her brought back out. But at this time, I'm going to take her in.
Can she post a cash bond today?
Pardon?
Can she post a cash bond?
If she has it, certainly she could post a cash bond.
Okay.
I mean, I'll allow a 10% on it, so that she doesn't have to go through a surety if that would assist on that. But it's that would be $25,000. I'll give a 10% privilege.
Okay.
All right. What were we going to do with the case itself?
The case itself, like I said, we received discovery. I think we have some ongoing negotiations regarding an offer, and she does have a substance abuse evaluation scheduled, I believe, September 10th.
So what I will do is I'll adjourn her case to September 17th, 2025, 9 a.m. At this time, the defendant is remanded. Her bond will be set at $25,000, 10%.
Will the court also order the scram?
Not at this time.
Okay, thank you.
All right. Yeah, that's why I didn't think I put that clip in there, because I didn't see if there was a part 2 to it. But apparently I just threw that clip in there anyways. Yeah, I don't know. Real quick. Linda, thank you so much for the 19 months. Enjoy Canada. Thank you. I have been. I've been here for. Has it been 2 weeks? No. I've been here for about a week and a half, and it's been absolutely lovely. It's awesome. I've really enjoyed it. So, but thank you for the 19 months. And Andy, Judge Simpson frustration fee. He actually had a really good day today. He had a great day today. There wasn't a lot of frustration in his docket. He just rolled through it. I think that was the only Mr. Allen moment today. But I didn't see the last, I don't know, hour or two of his docket today. So there's a chance that something else happened. But no, pretty much had a good day. Easy day. All right. I think there's only one case left. Best name on the internet, Judge Colin. This one is just a guy trying to fire his attorney. Just having fun, firing attorneys. Let's go.
James Lawrence.
I am.
All right, thank you and welcome. We're here on the record then in the matter of People versus Michael James Lawrence, file number 25-5447FC.
Sierra Coke on behalf of the people.
On behalf of Mr. Lawrence, who's present in the Crawford County Jail Division.
Thank you. So, Mr. Lawrence, we're here for a status conference today. Despite your location there in the jail, have you had enough communication with Mr. Vernon that you know how you want to proceed in this case?
Yeah, we've had a breakdown of attorney-client relationships. I'd like to have a new attorney. I mean, I've been offered some plea bargains that were supposed to be misdemeanors that I've signed that turned out to be felonies because he's read them wrong. I mean, he told me that the outcome of another guy's trial last week on the 28th would affect any plea bargain or anything that I would be offered because Ms. Koch would be upset with him. I'm not comfortable proceeding with this. I mean, you can't even get a 10% bond.
So I want to have you tell me everything that you want to, but I want to do so after I hear first from Mr. Vernon, and then I'll let you follow up, Mr. Lawrence, because I don't take lightly claims by a defendant that the attorney that he's representing him is not doing a good job. But there are specific processes that are in place for those types of disputes. The first starting point is you discussing with your attorney to see if you can come up with an agreement in terms of a meeting of the minds. The second step involves other considerations, which we might get to today and we might not. Mr. Vernon, though, I want to hear from you regarding Mr. Lawrence's claims.
So, I mean, generally they are true. He identified that I made an error in reading the plea to him, and if I may approach. Sure. So these are referencing the plea sheet that was provided to him. The first plea sheet that was provided to him identifies domestic violence, knowing or assaulting as a second offense, which would be a misdemeanor. The third offense notice was off to the side, and it was not read. I missed it. I had Ms. Koch draft a new one that made it so that it was easy to read.
I have no idea. I've only seen Judge Oakley live one time since that day, and that was yesterday or the day before. Hold on, what's today? Today's Wednesday, so it was yesterday. Or was it Friday? It doesn't. I don't know. But he wasn't there. I looked. I really want to see that hearing. I don't think we're going to see it though. I don't know how to look it up either because it's not a criminal case, right? It should be, but it's not. I don't know how to look up a record of an attorney being held in contempt. It's not the same way we look up traffic tickets and criminal dockets. But yeah, I would love to know the answer to that too.
Provided, so I updated that information with him.
So I'm going to ask you to stop. Mr. Lawrence has apparently left the facility, which is fine, but I'm not going to conduct any further proceedings with his absence. I'm simply going to adjourn the proceeding. I note that the reason I'm not continuing with any further colloquy is nothing.
He's not held in contempt yet. Even if it is criminal contempt, criminal contempt isn't a charge that he will have a record of. He'll go to jail. He'll have a jail record, but it's not, it's not a case number. He won't be on a docket. I don't know how to look that up. That's what I'm saying. But yeah, criminal contempt, you can spend, 90 days, 180 days in jail, but you don't have a case number tied to it. So I don't know how to look it up in the system. That's what I'm saying.
Do with Mr. Vernon, my credibility findings, Ms. Koch, or anything else other than Mr. Lawrence left. And while he may have the ability to physically leave the court proceeding, it's not going to affect how I proceed other than it's going to terminate my calling this case any further today. I'm not going to hear the matter any further, and if the attorneys can arrange for Mr. Lawrence to be brought either in person or via Zoom, then we'll conduct the hearing, but I'm not going to give any sort of benefit to
I think
Mr.
he got
Lawrence.
called out by the staff.
Mr. Lawrence, did you get called out by jail staff there?
This is
Right.
someone else with Judge Burmeister.
Can you state your name, please?
Well, they just put me back in here, sir. It's Michael Lorenz.
Mr. Lawrence, did you just leave the facility or did you get called out of the facility?
They called me out of the box, said that they had court with someone else with Burmeister.
All right, that's fair. So my concern, Mr. Lawrence, what I was explaining to the attorneys is that you just voluntarily left. And what I was explaining is that while you may be able to do that, I wasn't going to proceed any further on any hearing with your absence. So I'm glad that it wasn't you walking out, it was you being assisted out by jail staff, but I'm going to continue to say what I was stating before. Your attorney was explaining what I believe is his view of what happened and that he made a mistake in advising me of what a potential plea is, but he's got an updated plea offer. Mr. Vernon, did you wish to respond to any of the other statements by Mr. Lawrence regarding why he may need to have a new attorney?
So just to finish up that last comment, I had brought him the updated plea sheet a month ago. I mean, this isn't something that happened recently. This has been resolved for a while now. The second comment he made, again, I assume that sufficiently breaches the attorney-client privilege so that I can discuss the matter with the court.
Well, I'm not making any such finding. You're free to make whatever statements you want to, but I'm not making any such findings.
So he and I had a conversation regarding plea negotiations, and I identified to him that we wanted to get the best plea offer we could before my trial scheduled for last Thursday. And the comment I made was, it is human nature for an attorney or any other person for that matter, that if they lose, that they're less likely to be cooperative or amenable to further plea discussions or reductions. I had a conversation with Ms. Cope regarding the plea. She did not amend her plea. She did not change her plea offer. And I haven't had any conversations with Ms. Coke after last Thursday's trial. So Mr. Lorenz clearly took umbrage at the idea that my thought on human nature would reduce the likelihood of getting a better plea offer related to his charges after the trial we had last Thursday on an unrelated matter.
That's what I was just going to ask, is whether that was an unrelated or a related matter. Ms. Cope, did you want to respond to anything that's been said so far?
Yeah, I didn't change the plea offer, which I went over at the last hearing on 7/29 because of Mr. Lawrence's criminal history, which involves 7 prior domestic violence convictions, 8 charges, additional charge of stalking, additional conviction on
That's not true.
use of communication device.
Lawrence, stop talking.
And
You're
MD.
going to have an opportunity to respond, but you're not going to choose when you do it. That's not how the court system works.
Yes, Your Honor.
Well, I have his criminal history, in which I've talked to his recent parole officer. He's got 4 operating while intoxicated that obviously involved alcohol. Most of his domestic violence has involved alcohol. He has an MDOP. He had a perjury case that was dismissed recently. I mean, his criminal history is atrocious. So my plea offer had nothing to do with Mr. Vernon, everything to do with Mr. Lawrence, his criminal history, and the allegation that he, in this case, which I don't need to go over with the court, but involved multiple witnesses. And I thought the likelihood of conviction was high with a number of witnesses that had the same story involving him using a knife and threatening people with it while intoxicated. So my offer had nothing to do with anything to do with Mr. Vernon. And it's not going to change if he gets a new attorney. So if we are not able to resolve this case, given that it is a victim case, it was charged in June. The offer was made on July 2nd. The offer has not changed in the past 2 months. I'd ask the court to set it for trial since he is lodged. Thank
So
you.
I had the benefit of presiding over a trial last Thursday that the attorneys have referenced, but I want the record to be clear about what happened in that case, which was, it was a contested possession case. I dismissed at a summary judgment or a directed verdict motion one of the charges, which was met with objection by the prosecution. The jury found not guilty the defendant of the other possession charge. Is that an accurate summary at least of the charges at the end of the case, Ms. Cope?
It is, but it has nothing to do with this case.
I understand that's what you're saying, and I'm not questioning that. I'm just trying to make sure the record of this case is as full as I am aware of it. Is that an accurate summary of the charges, how they resolved, at least, Mr. Vernon?
Yes.
All right. So, Mr. Lawrence, did you want to say anything else now that you've had the benefit of hearing from the attorneys?
I would, Your Honor. No, I've never been convicted of a perjury charge. That was part of the plea bargain in my last case that was dismissed against the victim. I've never been convicted of stalking. The misuse of a telecommunication device had nothing to do with domestic violence. It was with an ex-wife's boyfriend years ago. I don't understand why my lawyer would come up to me and be like, his exact words is she's going to be pissed. You're not going to get a better deal if I beat her at court. I mean, I was lodged with Mr. Clayton. That don't make me feel good going to trial over that. I've never been a flight risk. I've never not showed up to court. I've always showed up to court. All I was asking was for a 10% bond. I live in Roscommon. I own a house in Roscommon, so I can take care of my affairs in case I do have to go and do some time. I've always showed back up to court. That's all I was asking. And basically he's saying, you're not going to get a good offer. She's not going to change nothing. All she wants is punishment. She went to the bond hearing with inaccurate. The first time on the record, she said I had got more than 4 DUIs, but you know how PSIs can be wrong. Well, no, I don't. I don't have more than 5. I've got 4. I don't have perjury. I don't have stalking. I just want it to be accurate. I'm asking the court for a 10% bond so I can at least get out and take care of some affairs and a new attorney. My case shouldn't have anything to do with whether she wins or loses in her feelings.
Mr. Lawrence, nothing you've said today convinces me that there's been a material breakdown of the attorney-client relationship or that there's any need for the court to act on your request, either with respect to bond, which your attorney can bring up at any time, or with respect to a new attorney. If you wish to ask for a new court-appointed attorney, there's a process that your attorney can go over with you through the MIDC, the Michigan Indigent Defense Commission, but I'm not convinced on this record that there's any basis for such a replacement. So Mr. Vernon's going to continue to be your attorney until I'm convinced otherwise or until the MIDC is. I'm going to set this matter for a new status conference next month, and to the extent you want to resolve the case by plea, great. If you don't, we'll set it for trial and we'll have the jury determine the issues. But nothing you've stated so far convinces me that there's been any wrongdoing, any misstatements, or anything else. And so if you can convince me later of a different outcome, I'm sure you will, but I'm not convinced now. The court will be in recess, and I'll see you for my next status conference at my next available date, where we can jointly determine how you want to proceed.
He just kicked him out. He just kicked him out, and then I just cut the clip right there. I guess that's it. That's all I got. Yeah, when you try to fire your attorney and find out that you're not good at firing your attorney, he's as good at firing his attorney as he is drinking and driving. Apparently, not good. He shouldn't do it. Anyways, I hope you guys enjoyed the show tonight. I do appreciate everyone hanging out. Biggin, thank you so much for the raid. Thank you for the super chats, membership milestones, gifted memberships, mods. You are awesome. Let's set it up. I'm gonna raid Lone Wolf tonight. He stopped by to say hello, so let's raid him tonight. Okay. That's it. That's all I got. I will see you guys tomorrow. Yeah. I'm trying to think of something. I feel like when I'm on camera, I'm nervous. I do this every night, but I'm on camera and I don't know what to say. So I'm just gonna peace out. You guys have a great night. See you tomorrow. Okay, bye. Go tell Lone Wolf I said hi. Hey Lone Wolf, when you get to Lone Wolf's channel, tell Lone Wolf that I said hi. Thank you. Okay, bye.